Hi, I'm Richard Elliott. I'm the Executive Director of the Canadian HIV/AIDS Legal Network, working on a range of HIV-related human rights issues, including all sorts of drug policy issues and harm reduction and so on. And I'm very pleased to have been asked to moderate this morning's panel, notwithstanding the challenging time slot we're in. I'm really impressed that all of you actually made it out at this hour. We've got a great lineup of presenters today, and I think we're going to have a really interesting discussion about human rights abuses in the war on drugs and how we may be able to use various tools and strategies to respond to those human rights abuses. We will hear from each of our speakers for about 5 or 6 minutes with some opening remarks, and we have a number of questions to put to them, and we'll have them bounce some of those ideas back and forth between them, and then we'll open it up to the room as a whole for your questions and conversation. And I think we can keep this relatively free-flowing and informal. I hope that at the end of the session you'll leave feeling inspired, informed, maybe you'll have thought of something that can be done as a human rights strategy for fighting back against the war on drugs. We'll see where it goes. It's been about 10 or 15 years perhaps since we began to see some real deployment of human rights language and human rights tools and principles to start questioning the war on drugs in a serious way. Obviously, many people have been working on human rights issues raised by the prosecution of the war on drugs for longer than that. But it's really only within that period of time, in my assessment, that we've started to actually get some traction at the international level, and we've started to see some successes at domestic level in getting courts and legislators to actually change law and policy, in part at least because of human rights concerns and to address the concerns that are coming forward. And I think that's very encouraging, but it's also just the beginning because there's an extraordinary amount of work that needs to be done. Between the adoption in 1998 at the UN General Assembly special session on drugs of the political declaration about striving for a drug-free world, and a decade later when there was a review undertaken within the UN system, there was exactly one resolution that was adopted at the UN Commission on Narcotic Drugs, in which reference was made to human rights. We'll perhaps hear a little bit more in the conversation that follows about how that came about and what the challenges were. But it's indicative of just how steep a hill there is to climb when we're trying to get human rights into the global discussion about drugs. I think, however, in the last few years, we've seen those human rights challenges really be one of the things that has helped drive a wedge into some of the former consensus, or at least apparent consensus, in support of drug control and prohibition. There are a number of factors, of course, that have helped challenge the dominant orthodoxy about drug prohibition. The exploding HIV pandemic linked to injection drug use, of course, has really shone a spotlight in a way that few things have on some of the negative health implications of the war on drugs. Budgetary pressures, of course, have called into question the current dominant approach. But so too has been the mounting evidence documented by various groups about the terrible human cost of the war on drugs. And I think that is something that we need to try to maximize. We need to try to leverage even more. So the speakers that we have lined up for today are going to give us some insight into how that's been happening at the international level and at the domestic level, and where we might go from here. Our speakers are David Barrett from Harm Reduction International, who has been doing groundbreaking work on human rights and drug control for many years. We have Anya Sarang from the Andrei Rylkov Foundation for Health and Social Justice in Moscow, who is leading sometimes desperate fight for the rights of people who use drugs in Russia against some fairly significant institutional odds. We have Tripti Tandon from the Lawyers Collective in India that has been engaged in a number of litigation and law reform efforts trying to use human rights tools to challenge abuses in the war on drugs. And we have Maria McFarland from the US program of Human Rights Watch. And we'll hear from each of them for a few minutes and then have some Q&A. So if I could ask Damon to start, why don't you set the stage for us a little bit at the international level? Where do drug control and human rights sit in the international legal universe, and how do they relate to each other?
Okay, so in order to do that, let me start with something a little bit smaller. I live in Sweden, and so let me start with a story from there, because that helps contextualize what I'm about to say. A little while ago, the police decided that they would conduct a raid in the morning, and what they did was they kicked down well, they didn't really kick down any doors, but they went into the houses of 6 high school students because they thought they were selling drugs. So they pulled these teenagers out of their beds in the morning, and not a single drug was found. None of them were doing anything wrong. Nonetheless, the anti-drug organizations in the country suggested, well, you know, it sends a message, doesn't it, that selling drugs isn't okay. And the police said the same thing, so the raid is a success nonetheless. And you know, we're in the US here. People here have probably heard of the Savannah Redding case, right? So Savannah Redding, being a high school student, another student said that she was selling drugs. What she had on her was ibuprofen, and she was searched by some female faculty in her underwear, and it was all very degrading. Now, she won a constitutional court case, and that was a violation of her constitutional rights. The reason I mention those things is that the human rights violations in the war on drugs are not just the big picture stuff that you're going to hear from, unfortunately, from Anya. And they're very, very severe, from people being executed in some places, people being tortured, people being incarcerated for very long times, people being detained arbitrarily. But it's a huge range of abuse, from right down to everyday infringements on people's privacy. And one of the problems, I think, and it's important to articulate it in this way, is that human rights abuses are too easily dismissed as the actions of individuals in the war on drugs, too easily dismissed as one abuse of government, one overzealous law enforcement agency, and each one of them is individual. Each one of them is just a law enforcement problem. It's a criminal justice problem. I think it's important to articulate that the human rights abuses in the war on drugs are systemic. And I'll tell you why, in my mind. I don't think this is anything people here don't know, but I think it's important to translate it into international legal language. My problem is this, and this is where we come to the international legal framework. What governments are supposed to do in the war on drugs, and how success is measured, maps almost identically onto human rights risk. So you have to control people's behavior. That's risky in human rights terms. You have to catch traffickers. You have to eradicate crops. You're supposed to get people into treatment and all of these things. You're in the realm of human rights problems already. So you better start with human rights scenarios in terms of risk assessment, and it doesn't happen. Moreover, at the international level, human rights isn't talked about because it challenges the system. So what you have is a system that's inherently risky, and where when abuse actually happens, it's not dealt with, because human rights and drugs are such it's been referred to as parallel universes by an international legal expert. And that's important to articulate, that this is a systemic problem. I mean, interestingly, that's a very serious word in human rights law when you're talking about a systemic failure, because it requires systemic change. I've written the odd report where a reviewer has said you should change that. Say systematic. You can say that it happens often, but saying it's systemic is very strong. It is the case. So I think that's an important thing to keep saying, so that we can immediately undo what is essentially a straw man argument that comes up a lot. Well, these human rights organizations, they say in China people are executed for drug offenses, and therefore the drug conventions have to be changed. No, that's not what we say. The drug conventions don't need to change for nobody to be executed. However, it's part and parcel of a bigger problem that needs to change. And while I'm going to talk just for a minute or two about the International Drugs Conventions for a second. Of themselves, they're not the cause of this, but they're a big barrier to changing it. So it's very important to apply other parts of international law to the drugs conventions in order to properly read them, to properly apply them, and to see where there's problems. And when you do apply international human rights law to the drugs conventions, 3 things happen. The first is that you identify complementarities, right? The drugs conventions aren't all bad. There's some parts of them are okay.
Damon, sorry, sometimes you speak so quickly so that it's hard to understand that. Can hear you.
Okay. Where did I get to? Where did I get to that you got lost?
Sentences, please.
When you apply human rights law to the drugs conventions, what you get is three things. You get complementarities, things where they share their goals. You get parts where there are tensions, and then you get parts where there's conflict. The complementarities, an example would be access to essential controlled medicines like morphine. That's vital for the internationally recognized right to health, for example. Human Rights Watch has done some great work on this, for example. Tensions arise in certain areas. So one would be extradition. There's a drug trafficking convention from 1988, and within that there's extradition elements. Now there's a big problem there if the place you're extraditing somebody to may abuse that person or kill them, for example. There's a tension. That's a big one. There are other tensions around the way drug treatment is considered within the drugs conventions. If you apply human rights law to those provisions, the tension can be relieved. But there are also conflicts, and I'm going to identify four, I think. One is indigenous people's rights around coca, for example, in Latin America. There's no way to implement the drugs conventions as written without infringing upon that, and I think of all of the things within the drugs conventions, that needs to come out. It's a historical injustice, and so on. Related to that is cultural rights and the manifestation of cultures. Similarly, the aim of the drugs conventions in this regard was to eliminate those cultural practices. From a human rights perspective, that's not okay. The third one is the manifestation of religion. And again, these are quite connected. The aim was that this shouldn't be allowed. So Rastafari and cannabis, for example. And then the last one is a bit more all-inclusive. It's the right to privacy, which is internationally recognized in the International Covenant on Civil and Political Rights. And here is where there's an interesting human rights question to be asked. There's a standard test to be applied. These aren't absolute rights. The government can infringe upon them, but it has to be justified. It has to have a strong justification. And there's some questions that need to be asked within that, including, was there no less restrictive means to achieve the aim you were seeking? Now that requires that other options were on the table at some point. I'm not sure that was ever considered. The extent of the infringement on people's rights has to be considered. And in that regard, and this is where I'll conclude, its duration has to be considered and whether it's subject to review. What we have here is a policy objective that's intended that this will never, ever, ever stop. Now that's a big problem in terms of asking a human rights question. When is it going to be reviewed? And was it ever considered that it should be subject to review? And that doesn't of itself bring down the extant system, but it's a very serious question that's asked if human rights law is at all to be taken seriously.
What's happening in Russia and efforts to make human rights real for people who use drugs.
Okay, my name is Anya Sarang and I come from Russia, which is arguably is the worst country in the world in terms of its very repressive drug policies. And here we probably compete with countries like China, where human rights violations are also very high level, but at least in China they have access to some basic health services for drug users, such as needle and syringe programs and methadone programs, whereas in Russia we're 50 years behind the rest of the world, and such basic services as methadone is still illegal according to the Russian federal law. and even talking about substitution treatment is illegal. We have all the possible human rights violations that happen in the world are especially severe in Russia, and I want to talk a little bit about our work to deal with these violations. We are a small organization, Andrei Rylkov Foundation for Health and Social Justice, and we started to work just a couple of years ago in 2009. And we decided to, before I used to work in larger international organizations, working with drug policy and HIV advocacy. And this advocacy that we were doing for 10, 15 years turned out to be absolutely ineffective. And if in the beginning, in late 90s, there was some support for harm reduction efforts from the government, by mid-2000, there is strong opposition, strong vocal opposition from the Ministry of Health to even harm reduction programs such as needle and syringe programs and of course substitution treatment. So we decided not to waste our energy on the traditional advocacy methods such as educating the decision makers and round tables, discussions how to make people happier and life better. It doesn't work in Russia for some reason. Nobody's interested to make people happier. So we decided to focus on more precise and focused action, such as human rights work, but focused on specific cases. So not human rights in general, but we work with our friends whose human rights have been violated, and in some cases we developed this into strategic litigation. So we started 3 years ago to focus on strategic litigation cases to target the main problems with the Russian law, but not only with the law, but also with the practice of law enforcement. For example, arrests of drug users, planting drugs on people, and so on and so on. So, and also at the same time, we run a needle and syringe program in Moscow, which is it's not illegal, it's legal, but it's not supported, and it's opposed by the city government and by the country government. So we had this service program, the health program, working with drug users on the street, and at the same time we had the human rights component of our work, focused on strategic litigation, working on several cases to target the Russian law. And this human rights component, I mentioned that we did the court work. So with the help of our colleagues from the Canadian HIV/AIDS Legal Network and from Harm Reduction International, we do a lot of, and from Human Rights Watch, of course, we did a lot of work on documenting the violations and report these violations to the UN system. So UN has this number of human rights bodies, committees that monitor the conventions and treaties, and we try to feed our documentation to these committees. And at the same time, we work on the country level within the court system. But the Russian, they say in Russia that the first level of justice for the Russian people is the European Court of Human Rights. So all the work that is done on the national level is more or less formal, because the court system in Russia is very corrupt, and all the cases that go through it, the only hope for justice is when you actually come through the national system and reach the level of international human rights bodies. And this year we decided to kind of merge, because these two components that were not connected with each other. We worked on the street with drug users. helping them with drug issues, helping them to like find hospitals or rehab programs or so on. And we worked on the international level with the UN committees and with the European Court on Human Rights. But this year we decided to like merge these components of our work and started a street lawyers project. So it's like bringing the legal aid to the streets, and it's not only like these big strategic cases, but maybe day-to-day needs of drug users on the street. And we decided that it's too difficult and expensive to use like the big-time lawyers and professional legal aid. So we decided to focus on training ourselves, our social workers, outreach workers in legal issues, and make them mediators between drug users and between the legal system. So whenever they have conflicts with like whatever medical services, not access to some health care, or they have problems with police, or they are like under trial in courts, we try to interfere and like represent their interests in these institutions. So this is our attempt to link the big strategic litigation work and our work on the street. And we just started, but it's going really well. Now the first like 3 months, we found out that this on the street human rights and legal work is as essential for people as the health care. And we are looking forward how this will develop in like, into this bigger strategic picture.
Thank you, Richard, and very good morning to all of you. Before I start, I have an admission to make. I'm perhaps one of the very few Asians who are present at this conference. And I'm of course really inspired by hearing the work that's been done in many states, in many countries of the world. But I'm also really embarrassed. I come from a region that is not leading on any drug policy reform, but it's only leading on human rights violations and excesses committed in the name of war on drugs. And I'm particularly embarrassed about being, perhaps coming from India, which, unlike many other regions and the other countries in Asia, like China, Singapore, where of course human rights is not really something you can work on. I come from a country which is, constitutional, parliamentary, vibrant democracy with independent organs of the state, and also a country that lent its name to cannabis. So I'm sure you're all aware that the British we were referred to cannabis as the Indian hemp, Indian hemp plant. So I come from a country and a culture where cannabis is really part of life, and of course human rights are also fairly integral to our legal system, but yet we don't have much to share in terms of drug policy reform or progressive changes. And I'm just going to take on from where what Damon said, and also going back to what Richard asked me to do, which is to tell you how different machinery, different organs of the state really relate to international law, to drug conventions, and how that plays out sometimes favorably and sometimes not so favorably when you're coming to drug policy reforms. So, like I said, we have 3 organs of the state. So we have the executive or the government, which is really the agency which is most concerned with drug conventions and the obligations, because it's really for the government to decide which convention to sign up to and which not. In fact, in India, we've had cases where civil society has taken the government to court and asked the court to injunct the government from signing up to certain conventions. But courts have been very clear that this is the prerogative of the government and there's no interference from parliament or from the courts whatsoever. So that's really where the policy decision of following prohibition and signing up to conventions is made. The second is, of course, the parliament or the legislature, whose job is really to make law, and of course make law which is in accordance with the obligations undertaken by the government when signing up to conventions. But here, parliament, of course, has some leeway. So Parliament can choose to deviate from, so while respecting, of course, the spirit of the convention, Parliament can choose to deviate and adopt something which is different or not contained in the conventions if it feels that that is relevant to the national context and in the interest of the public. And maybe this is where room for countries to really have reforms, room for countries like Uruguay or much of Latin America. Perhaps this is where this stems from. And the third is, of course, the judiciary or the courts, which really are perhaps the least concerned with what is contained in international drug conventions. The judiciary's job is really to apply and interpret the national law in accordance with the Constitution and the human rights principles, the fundamental rights contained therein. Also, India, much like some of the other Commonwealth countries, has a dualist system of law, which is that international law doesn't automatically get incorporated in our domestic legal system. It has to be enshrined by way of a statute. And courts here have a fairly interesting role to play, that they are, of course, supposed to interpret national law, keeping in mind what is contained in international law. And their job is really to interpret in a way which is in conformity with drug conventions and also to avoid conflict. And I'm just going to give you an example of how the Indian Supreme Court really used this sort of ingenuity to deal with a constitutional challenge to our narcotic laws. So in our overzealousness, the government enacted a law which barred courts from reviewing sentences given to drug offenders. So there was this prohibition, this overall bar on the judiciary from suspending or commuting any sentence which had been awarded to a drug offender. So it was funny. So if the lower court, the trial court, actually sentenced you to 10 years or 20 years, and you had a right to appeal, Superior Court could entertain your appeal, but it could not touch your sentence. So while your appeal is being heard, you would still remain, in jail. They just couldn't release you. And the justification given by the government for this is language from the drug conventions. So they said that the drug conventions clearly say that courts should consider the serious nature of drug offences while considering early release of drug offenders. So the government interpreted this language of the convention to say, no, drug offenders must not be released at all once they have been convicted. And the Indian Supreme Court actually looked at the convention and said, yes, we see that there is this language, but it says that the courts must consider seriousness of the offense while considering early release. The convention never said that the courts cannot release the offender. And then the Supreme Court finally said that curtailing powers of judicial review is absolutely against the Constitution. So whether it's contained in drug conventions or not, we don't care. We will follow the constitutional rigor, and this provision was struck down. So this is a very interesting way of balancing what is contained in the convention and applying domestic legal arguments. The third point I want to come to is just to take you through some examples of the work that the Lawyers Collective has done in trying to really adopt the flexibilities within the drug conventions, and how really to impress those upon our government and our parliament and our courts to really say, okay, the conventions of course require prohibition, but there is this sort of flexibility, there is this sort of predominance and supremacy of constitution and human rights law. But as you will see, we've been successful in some places and not so successful in others. So the first example is that of lobbying with the Indian government on increasing access to opiates for medical use. Now this is very clearly, as Damon mentioned, this is part and parcel of the conventions. This is very much what the conventions seek to do, balance and make sure that narcotics are available for medical use. But the Indian government had such stringent provisions that despite being a major producer of morphine, our own patients did not have access because of the stringent conditions in the law. So for a long time, this was before the courts, and the argument was the right to health and all of that, but it really didn't go very far. It was only recently that we adopted, fortunately or unfortunately, some of the reports of the International Narcotics Control Board, which have raised this as a concern for India. And of course, the government takes the INCB very seriously, very, very seriously, much more seriously than any other international law body. And using language from INCB reports and the drug conventions, they finally agreed to amend the law to enhance access to opiates for patients. The second example is that of the Parliament. Now, Indian law criminalizes consumption of drugs also, which is, as you all know, is not a requirement under the drug conventions. But they're again very overzealous and taken prohibition to another level. So recently we were lobbying with Parliament, and we really argued that this is not. So while we agree that our law has to be in line with drug conventions, this is not a requirement, and obviously doesn't serve any public health or public interest kind of purpose also. The Parliament wasn't too keen, and they said, well, it's up to us, and we don't want young people to get involved with drugs. So while we don't agree with punishment, but we think going soft on drugs and sending this message that we're decriminalizing consumption is not going to go down very well. So they really didn't buy the whole convention argument. And the third example is that of, excuse me, of courts. So in India, we have the death penalty for drug offences. It was a mandatory capital sentence for a second-time offender involved with a large quantity of drugs. And we used some of the seminal work that Damon and his colleagues at HRI have done on arguing that the death penalty is one only for the most serious crimes, and drug offences are not the most serious crimes. And so we mounted this challenge in court, and apart from the human rights argument, we also argued that death penalty is not part and parcel of the drug convention. So the conventions only talk of deprivation of liberty and not deprivation of life. So this is again something that we had tried to argue. It was a partial success while doing away with the mandatory death sentence. The court really preserved death penalty per se, although this is up in appeal. So of course, if you see, it's very convenient when they want to apply the drug conventions, they apply it. When they don't want to apply it, they say, well, we have the freedom and the flexibility and the independence to go much beyond. But again, it makes me wonder whether our state, our systems really interpret conventions and international law, and perhaps, of course, on the basis of convenience, but also on the basis of who's talking to them and whose concerns and whose interests are they really concerned about. So in the first case, the morphine access, we were talking about cancer patients. These are respectable citizens who deserve, they deserve all the care and the sympathy. So therefore, I think the government kind of, was okay to move along and amend the law. In the second case with Parliament, we were talking about drug users. No one cares. So it doesn't matter. It really doesn't matter what the convention says. As long as they're drug users, we can do what we want to do. And in the third case, the death penalty, we were talking about drug dealers. We were talking about people accused of trafficking. So really, I think your interpretation of international law, national law also depends a lot on who you're representing, the value and worth that they hold in society. And I think this is where our drug conventions and human rights law, I think, is one area of challenge that we have to get around.
Let me step out of this a little bit because Human Rights Watch doesn't do litigation. So let me explain a little bit about how we work and what we focus on. We're a large international organization. We work in over 90 countries around the world on a wide array of human rights abuses and violations of the laws of war. So abuses committed in the name of drug control are part of that, but not the exclusive focus, for sure. We have a methodology which boils down to something like investigate, expose, change. We have researchers who visit countries, who investigate in depth human rights problems, who are experts in an issue or region, and then they write reports about their findings based on interviews with the people most affected. We try to publicize those widely to draw attention to the problem, and then we try to do advocacy on the basis of those reports to change policies, to influence decision makers who have a say and who can change things. In the realm of drug policy, our Health and Human Rights program has actually been doing a great deal of work on a variety of abuses committed in the name of drug control. So, for example, compulsory drug treatment in Vietnam, Laos, and Cambodia is a big focus of our work. We've done a lot of work on access to life-saving medication, to pain relief medication, on how abusive policing gets in the way of those rights, on the rights of drug users generally, who are often stigmatized and tortured and beaten and abused. Aside from that, though, which is, as I said, a pretty fairly well-developed body of work, in Latin America, which is where I was working, we saw a lot of other types of abuses that were being committed in the name of the drug war. I used to be the Colombia researcher for many years, and the issue is a little bit complex, right? Because Colombia has been at war for over 40 years. You can't boil everything that happens there down to the war on drugs. There's a war there that's internal that involves left-wing guerrillas and right-wing paramilitaries and the government and many other interests. So let me just talk a little bit about some of the tools that we use there. When I started working on Colombia, Colombia was receiving a lot of assistance from the United States through Plan Colombia, which was meant to be initially an assistance package to build up security forces in Colombia to allow them to supposedly fight drugs. Eventually that broadened and included terrorism and a wide array of security challenges. Plan Colombia was attached to human rights conditions. So one big area of focus for us was trying to get the US to make sure that Colombia was meeting those human rights conditions. So if you were giving money to the Colombian military, make sure that the military wasn't abusing human rights. In particular, we had documented for years how the military had been tolerating abuses committed by the right-wing paramilitaries, which themselves were major drug traffickers, and they were turning a blind eye to that. We had some limited success in that area, and I'm seeing Sanho Tree in the audience, and I believe he was involved in these discussions many times. We also did a lot of work documenting the atrocities committed by the paramilitaries themselves and by the guerrillas themselves. I did work on a government plan for demobilization of the paramilitary groups, where they offered them sentence reductions in exchange for supposedly turning in their weapons, and a lot of them got off with no criminal sentence after years of committing massacres. Colombia has 4 million internally displaced people, often as a result of abuses by these groups. And what I found was, yes, there were abuses committed in the name of fighting drugs, for sure. But there was also a problem with these armed groups committing horrific abuses because they were motivated by the profits that would come in from the drug war. The illicit market in drugs was fueling human rights abuses by criminal organizations, armed groups. And they were intensifying a war that had already started and making it just much worse. Moreover, we were seeing incredible corruption throughout the government. The paramilitaries had infiltrated very high levels of the Colombian government. Fortunately, there were some investigations while I was there into members of Congress who were linked to the paramilitaries. About a third of Congress ended up coming under investigation. So we tried to support those investigations. Let me back up a little bit, because then I moved on and I started working on the US more recently. And in the US, we've found, and have worked on for many years, a very, very harsh set of criminal justice provisions, policies, that are to a significant extent driven by this notion of tough on crime and the drug war, but aren't exclusive to that. You know, the US has gotten tough on kids who commit crimes. That's why you have juvenile life without parole in the US, not just for drug crimes, but for all sorts of offenses. There's this notion that you have to be very harsh, and that the criminal justice system with tough penalties, with the death penalty, with life without parole will solve all those issues. That being said, a very large share of what's happening here is driven by a war on drugs. And we've done lots of reports over the years on disproportionate sentences for drug offenses, on the disparities in sentencing and in arrests for drug offenses by race, because clearly African Americans are far more affected by drug law enforcement than other groups. And so we've tried to influence the debate from the perspective of there's disproportionate sentencing, there are racial disparities, this amounts to discrimination, it violates human rights. This all brings me to where we are today, which is after all these years of extensive work on abuses related to the war on drugs, internally we started to have a discussion, which was, well, why aren't we looking at least one of the root causes of all these abuses? And that is the criminalization of drugs itself. And that's not something that you have a human rights standard explicitly on. You know, there is no provision in the International Covenant on Civil and Political Rights that says drug offenses should not be criminalized, or that personal use and possession of drugs are clearly protected and you can't put someone in prison for that. And that's a big factor driving a lot of what's happening. But we decided earlier this year, and as part of this analysis, that we actually would take on the criminalization of drugs. On the one hand, our analysis is, and let me give you a very wonky kind of legal analysis here. The point is, personal autonomy and privacy rights are not something that you can just restrict willy-nilly. Certainly, governments are entitled under human rights law to impose legitimate restrictions on those rights. You are able to regulate certain things. However, those restrictions have to be for a good reason. So, say, protecting the health of the population can be a legitimate purpose for restricting certain rights. Morality is not. Enforcing majority moral views is not a legitimate basis for criminalizing something. That's why you can't criminalize homosexual activity, for example. And we all agree on that, and increasingly there's an agreement on that in the US and internationally. Well, the same is true for drugs. Just because some people disapprove of drug use doesn't mean that you can criminalize it. Well, what about harmful drug use? Because a lot of people will say, well, you know, people who use drugs commit horrible crimes to further their use, or under the influence. Well, then you have to look at whether criminalization is necessary to address those harms. And it's not. You have criminal law tools that allow you to go after those crimes that people commit while under the influence of drugs. You don't need to criminalize the use of drugs, per se. And the fact is, there are many, many people who use drugs every day and don't commit any crimes. And if they are harming anybody, it may be themselves or maybe not. But that is a matter that's private. And there is no room for criminalization there. So that's our analysis. Our argument now is states should decriminalize use and possession of drugs for personal use. With regard to distribution and production, it's a little bit more complicated because it's not just something that you're doing in private. However, our analysis now is that the drug war, the criminalization of drugs, the prohibition on drugs has fueled an illicit market that is so powerful that it's basically impossible to stop the crimes and abuses that are being committed in furtherance of that market, unless you change them. So that gives us a slightly different take on the things that I was saying in Colombia, right? Because not only do we talk about the abuses that the government was committing to enforce laws, but you can also say this prohibition is in itself supporting many of the groups that are also committing abuses, that are also committing crimes. It's something that's happening in Mexico too. And we've heard from other people at different times in this conference about the horrific cost of the war on drugs in Mexico. And that's not only, and we've written a lot about how the government and the military have committed abuses, it's not only from law enforcement, it's also the profit motive, the fact that this continues on and on. And I think, we'll have to see how we use these tools and these arguments going forward, but that's our current position. So I'll stop there.